and welcome to another interview with Litigators Corner. I am fortunate and privileged to have with me today a very esteemed mediator, Jeff Kichaven. I've actually had the pleasure of making bar presentations with and mediating with Jeff, and he is an excellent mediator. And Jeff is here today to talk to us about what he wants to see as a mediator mediation and his thoughts on how the pandemic has affected mediations. And as importantly to all of us is questions about what you always wanted to know, ask a mediator, but we're afraid to ask. Jeff, thank you for coming today.
Well, Hillary, thank you so much for having me. I'm very proud to say that I have been a member of the Beverly Hills Bar Association for almost 40 years. The association does outstanding work in so many different arenas, and I'm so happy that I'm able to contribute to this effort today.
Well, we appreciate that, Jeff. Jeff, tell us a bit about your practice and what you do.
I'm a full-time mediator. I do mainly business-to-business cases. I've been a full-time mediator for almost 25 years now, Hillary, and it's my own independent practice, which allows me to focus completely on the needs of the clients without any distractions.
That is super. And for those of you who don't know, Jeff has a wonderful newsletter that he sends out. He's very active with, so I would recommend that you take a look at it and subscribe if you're interested. Jeff, we are seeing what I would say an unprecedented changes, not only in the courthouses, but in ADR. And you are at the center of this because you are so instrumental in resolving, not only resolving cases when people voluntarily go to mediation, but let's face facts, the judge is going to order parties to attend. What is your feeling about how the pandemic has changed mediation?
Hillary, that's a great question. The pandemic has changed everything in society, and mediation is no exception to that rule. In the shift from in-person mediation to virtual mediation, let's be honest, we've lost some things and we've gained some things as well. We have lost the immediacy of in-person communication, and that's not to be underestimated. At the same time, though, we've gained some very significant things. I think the principal gain is in the willingness of people to participate in face-to-face communications once again. Because when people are in the comfort of their own homes, I think people are more willing to have joint sessions, more willing to have direct communication, more willing to undertake appropriately more responsibility for the outcome of the mediation. Why is that? I think it's because in the comfort of your own home, people are less agitated, they're less antagonized. The people who are speaking tend to be less tightly wound, and the people who are listening tend to have calmer reactions to whatever they hear. I think that when people would come to a mediation office or a lawyer's office, they would have to gird up, they'd have to put on that suit of armor, the Brooks Brothers suit and the white shirt, the yellow tie, whatever it happens to be. Now people are sitting in the comfort of their homes, generally dressed a little less formally. Their dogs and cats are there, their children are there, snacks are nearby. And I think because people are more relaxed and more literally at home with the process, we can have more direct communication productively and without the antagonism that oftentimes in the past has made people shy away from that direct communication.
Do you think the fact that I've experienced this, and I'm sure you have, the mere fact that these people are in the same building or the same room who may hate each other or be fighting over, there's a lot of tension. Do you feel that's alleviated by having the virtual mediations during the pandemic?
Yes. That's the part of the antagonism that has dropped out of it. There's a certain safety in sitting in your own home office or your own kitchen table. You're not in the environment built for combat, which is the law office. You're in an environment built for comfort, which is more typically your home or your own home office.
Have you seen, I know from my own practice, I've seen people who are a lot more willing to go to ADR because of the delays in the court process. Is that been your experience, or are you seeing more of an influx of ADR cases, or what's your experience?
Mediation and arbitration seem to be as popular as they have ever been. Yes, there are people mediating and arbitrating. I don't want to overgeneralize, though. There are some people who say, yes, we just need to get the darn thing over with. Let's get into a mediation, or let's arbitrate quickly because of the unavailability of trial dates in the courts. There are other people, though, who are just as happy to put things off and not bring things to a head. So in the large economy in which we operate, with a lot of different cases and a lot of different people, I don't want to overgeneralize. At the same time, as I said before, mediation and arbitration do seem to be as popular as ever.
And Jeff is a mediator. I know that mediators send out emails and tell us what they want. What as a mediator do you really want to see from us lawyers, besides a thorough brief and being prepared? What do you want to see from us and your clients?
What a great question. What do we really want to see? We want to see people who are committed to working hard to make deals if at all reasonably possible. We want to see lawyers who understand the appropriate division of responsibilities between the mediator, the lawyer, and the client. The mediator is responsible for creating the environment in which the lawyers can do the best job possible. The lawyers are responsible for negotiating on behalf of their clients and presenting to the client a decision. Here's the best deal possible. And it is the responsibility of the client to participate along the way, to see how their lawyer is doing, to see what their lawyer is doing, to collaborate with the lawyer and the mediator in creating negotiation strategy, inventing options, introducing elements besides money sometimes to try to get deals done. And ultimately, it is the client's responsibility to make that decision. Does the client prefer the deal, the best deal possible under the circumstances, or does the client prefer the litigation alternative? So we want to see people who are actively involved in that process, who are not just there to see a mediator take over the process and do everybody else's job for them. The mediator, the lawyer, the client all have distinct jobs and responsibilities, and everybody has to be committed hard to working hard within those roles to see whether settlement is reasonably possible.
Jeff, you have very generously offered and volunteered the subject of everything that lawyers always wanted to ask a mediator, but were afraid to ask. And I have conferred with our litigation committee, and we do have some questions for you. Our first question is, some lawyers only want retired judges as mediators. Do you think it's, I know that you're not a retired judge, but do you think it's preferable to have a retired judge as a mediator, or do you think that judge would really push for a result or try to take control of the mediation to get the result that they want?
Hillary, the question of the retired judge or people from other professional backgrounds, and let's also remember there are some outstanding mediators in our community who are not even lawyers. So it's not just a distinction between judges and lawyers. We're all professional mediators. There are some people who used to be judges who are outstanding mediators, and there are some who are not. There are some lawyers out there who are outstanding mediators, and there are some who are not. And there are some people from backgrounds other than law who are outstanding mediators, and some who are not. So let me refocus the question if I can. The question is, what are the skills that you need to bring to bear? What are the skills that you need a mediator to bring to bear in order to help you get your case settled, if at all reasonably possible? So many judges have the required skills. Lawyers have required skills. Sometimes people from other backgrounds, an engineer in a construction case, or people with other different professional backgrounds may have the required skills. The most common thing is that somebody is not communicating well with somebody else, and you need a mediator who can gain the trust of the parties and help people communicate better with each other, sometimes through face-to-face communication, and sometimes through what we call shuttle diplomacy, and sometimes it's a mix. Sometimes the lawyers on opposite sides of the table are not communicating well with each other, and you need a mediator who can help to bridge that gap. Sometimes lawyers are not communicating well with their own clients, and you need a mediator who is sensitive to the subtleties of the attorney-client relationship and can help bridge that gap. So in selecting a mediator, one of the most important questions is not, was the person good at their last job? The question is, the person good at their current job of being a mediator? And so ask yourself, what are the challenges that we're trying to meet? What are the reasons the case has not settled yet? What are my expectations of the mediator? And then find a mediator who has those particular skills and abilities. Whether the person is called a judge or a lawyer or an engineer or real estate professional or a chemist in a patent case, whatever it happens to be, those are the important questions.
And do you feel a joint session in mediation is really helpful? Or do you think it's more beneficial to separate the parties?
Oh, Hillary, I'm going to give you that old law school professor answer. It depends. One of the things that we try to do in good mediation is to customize every case. There are many cases where a joint session is appropriate, and there are many cases where a joint session is not appropriate. And what the mediator needs to do in concert with the lawyers is to figure out, is there a reason, is there a purpose to have a joint session in this particular case? The way that we do that is we get briefs from the parties, and we have those all-important telephone calls and now sometimes Zoom calls with the lawyers before the mediation takes place. And we ask those open-ended questions. What are your expectations of me as mediator? What are the challenges that we are facing? Tell me about the people involved and your relationships with everyone. And hopefully you've picked a mediator with whom you're comfortable discussing these things, including the relationships between lawyers and their own clients. And then you get a sense, would direct communication, would a joint session help in this case? Maybe just a joint session between the lawyers so that they can explain things more fully to each other. One of the great benefits of a joint session is that it so beautifully sets up the caucusing that takes place after that joint session. Let me compare and contrast. Let's say we have a joint session where you explain your views on one or 2 points. We try to tailor them these days so that it's not just, what do you think, what do you think? We try to tailor them so that we isolate what the keystone issues really are. And then we can have a joint session focused on that. It tends to minimize the antagonism and maximize the progress. Then we can go into a caucus, and if we've done it right, Hillary, those caucuses can be really productive after a good joint session. Because the purpose, after all, is to try to have some impact on the client and to get the client to consider some options which perhaps the client had not previously considered regarding how to settle the case. So let's say we have had a joint session. I can then go into a caucus and I can say to you in the presence of your client, well, Hillary, we had that joint session and Mr. and Miss X on the other side had the following 3 points to make. Point 1 I didn't think was so hot, but points number 2 and 3, I thought they made some sense. What do you think of that? And you and I can have a discussion of point number 2 and point number 3. And if they made some sense, you can acknowledge that they made some sense. Because usually the cases that come to mediations are pretty close cases. If they were so easy to win, you probably would have just gone and gotten your summary judgment anyway. So we can have this conversation in front of the client, a discussion of what Mr. or Miss X had to say in the joint session. And we want that to have some impact on your client. By contrast, if we have not had that joint session, I simply go into a caucus with you and your client, and I say, well, Hillary, your position is very interesting. And then cribbing from the other side's brief, I say, you know, there are 3 arguments against you. Number 1, number 2, number 3. What do you think of number 1, Hillary? What do you think of number 2? And when we do that, The way I like to characterize it is that the mediator looks much more like the sponsor of the argument and less like the narrator of the other side's argument. And it looks less like we are having a conversation and more like we are having an argument. And if the mediator and a lawyer have an argument in the eyes of in the presence of the client, dollars to donuts, the mediator is going to lose that argument every time.
Right.
Why? Because the client understands that you as the lawyer, you are the fiduciary, you are the champion, the gladiator, the one with the duty of undivided loyalty. Whereas the mediators, we're maybe smart people, but at one level or another, we just want to see a deal get done. We are not solely on the client's side. So there's that built-in orientation that the client is going to have to believe and trust their own lawyer over the mediator. So we try to do things to keep down to an absolute minimum anything that might be perceived as an argument in that caucus and have a conversation to maximize the persuasive impact on the client. And when we have set that up with a joint session beforehand, believe me, it goes way more smoothly.
And I've actually had those experiences with Jeff where he's very effective and very good about those kinds of things. So that is true. And I think it is true. There is always the perception by the client that the lawyer's on my side here to fight for me. The mediator's just here to settle it because that's their job. And see, one of the questions our committee had was, if you have a situation, which it does come up, where one of the opposing party, the opposing counsel, has a regular relationship with the mediator. In other words, this mediator is one of their go-to people. They work with them all the time. They've had 10 or 20 mediations with them, which usually comes up because often it has, here's my list, here's who I'd like. And sometimes they're trying to say, oh yeah, I've worked with them once, or no, I've never worked with them before. So sure, we'll try this one. They seem well qualified. How do you, as a mediator, assure a party of a fair settlement and mediation process other than the standard stuff when the client is going, I don't know if I even want to be here. I don't like what I'm hearing. You know, this guy knows the mediator. This is just one case. They get lots of business from them. Of course, they're going to want to go with them.
It's a fair question. How do you assure yourself that your mediator is impartial in a repeat player syndrome? And here are some answers. Let's say I have done 20 cases with lawyer X, and lawyer Y is considering me in a case against lawyer X. Lawyer Y asks the question fairly, how do I know you'll be fair to me? After all, you've worked with lawyer X so many times in the past. And I think that there are two ways to answer. One, you can say to lawyer Y, well, in the last case I did with lawyer X, the lawyer on the other side was Mr. or Miss So-and-so. And in the case before that, the lawyer on the other side, the lawyer in your shoes, was Mr. and Miss So-and-so. And in the case before that, here's who the lawyer was. Here's their phone number, here's their email, check me out. Ask if they feel they were treated fairly. And if I was able to deal fairly with the person in your shoes in cases number 17, 18, and 19, I think the chances are pretty good I'll be able to deal with you fairly in case number 20. And then, Hillary, there's also a structural check on mediators' ability or willingness to tilt the playing field, so to speak. And that is the person with whom we've been dealing regularly is on one side of the aisle or the other. Let's say it's a defense lawyer representing an insurance company. Mm-hmm. And we have the plaintiff's lawyer with whom we're going to be dealing the first time. Well, the plaintiff's bar and the defense bar as well have very robust listservs where they talk about mediators as well as arbitrators and expert witnesses and judges and other topics. So if you screw one lawyer, and that lawyer then has the ability to go onto a listserv and tell everybody about the experience, that's a kind of a structural check in the way the marketplace for mediation services works. And it keeps mediators from tilting the playing field.
Because you will get that reputation of like, oh, they were so biased towards these.
Reputation spread very quickly, and the last thing any mediator wants is a lawyer going onto these different listservs saying, so-and-so was unfair to me.
No, that is a good answer. That is a good point. What are some of the signs as a mediator that you've seen when you're working really hard, everybody, the lawyers are working hard? What are some of, and the deal may fall apart. What are some of the early signs as you see it? The deal may fall apart.
Well, one question is, why are people in mediation in the first place? Have they come truly voluntarily? Have they paid money to the mediator? Have they literally bought into the process? Have they paid their lawyers to prepare a good, solid mediation brief? Sometimes you look at whether people have traveled. In the olden days, we would ask if people traveled physical distances to come to the mediation. Are people committed to the process? And when people are there voluntarily, financially, and otherwise invested in the process, then I think as mediator, our inclination is to keep going, not call things off, even when there seem to be impasses. And there are a number of things when you have this dead space where one side's not moving, the other side's not moving. One thing that I often find effective is to call out the two lawyers, the plaintiff's lawyer and the defense lawyer, and have a little heart-to-heart with the two of them. To the plaintiff's counsel, who say, look, you've been stuck at $100 gazillion for several hours now. You know the case is not going to settle for $100 gazillion. To the defense lawyer, you turn and say, you've been stuck at $1.98 for quite some time now. You know the case is not going to settle for $1.98. My friends, we need to come up with plan B. And we work collaboratively. Again, the mediator creates the environment for the lawyers to do their best work. The lawyers know their clients best. A lawyer may say, listen, I can get my client to move, but I got to see some sign of life from you in the negotiation. I need you to come down to X. And if you can come down to X, then that'll give my client some hope. And I think we can come up to Y. So there's this kind of simultaneous movement that's negotiated. Or a lawyer may say, listen, I just need a better answer from you on this question, why this piece of evidence will or will not be admitted, or why this measure of damages is appropriate, whatever it happens to be. And so by bringing the lawyers together and giving the lawyers an opportunity to figure out the way forward, those lawyers who know their clients best almost always come up with a way to break the logjam.
And what are some of the, we've all had the situation, one, God forbid, you get an oral agreement, the person leaves and decides next day they don't want to do it. Or you have the situation where a client signs and they're like, I get the call the next day, hey, can I redo it? Can I change it? I don't want to do it. We get that. Or right when they walk out the door, you get a call an hour later, hey, can we ever call everybody back? We don't want to do this. What are some of the signs, early signs of what settler's remorse?
Settler's remorse can happen in any case. And part of the way to prevent settler's remorse is to make sure that the client really understands the deal they're making and has been invested in the process of making that deal. I think that you're much more likely to get settler's remorse in a situation where all you've had all day is shuttle diplomacy with no joint session, with no direct involvement by the client, where the client is estranged and alienated from the mediation process. If the client has had no real investment in the process that leads to the result, then I think the client is much more likely to have misgivings about that result. That's why I think wherever possible, joint sessions, keeping the client actively involved in the communications, making sure the client understands what the choices are in the negotiation at every step of the way and is on board with the choices that are made. There's an old saying, somebody else invented it, you don't have to work very hard to persuade someone of the wisdom of their own ideas. And to the extent that the settlement is in material part the client's own idea, I think you're much more likely to prevent the kinds of misgivings that you're describing.
No, I think that's very true. That people are much more, if it's their idea, people are much more likely to do it. And I know that I've used that in mediation too, and I've advised clients without waiving attorney-client privilege that let them make, they're going to want to make the final offer. They're going to want it to be their idea. I'm not saying it is, but they're going to need that emotional push to get where we need to go here. You know, and it's been my experience that most clients are okay with that. They understand that as long as they feel that they've had a big hand in structuring the deal or negotiating. So maybe it is the last word does come from the other side, but it's the final offer includes their input. So
Right.
and everything. So during COVID, is it your experience for courts that are referring these in, are you getting the sense that that courts are more aggressive in putting cases into ADR, other form, and mediation and arbitration? What's your experience so far?
I think that question is better directed to you than to me, because when I see people in mediations, they're there and I'm enthusiastic about working with them, and I hope they're enthusiastic about working with me. As to whether judges are more aggressive about ordering people to mediation, I think that's a question better directed to you as a litigator. What do you think?
I think that it's something that I tell them more often. Look, here's the reality. If we can wait it out for a bit, but the chances you're not going to get a trial date till this date. Likely it's going to get kicked if the pandemic increases. I have to tell you, look, I don't know. And, some people are willing, if it's a year in, they're like, look, I'll go to trial. And then they're like, God, I didn't know it was going to take this long. Because, and sometimes people underestimate how long it takes to get to trial anyways in the litigation process. That's not uncommon, but during the pandemic, it's even more so because I'm having to tell them, yeah, I got to tell you, this is when you're looking at to get this. Has the pandemic changed your approach? Do you find yourself or the attorneys you work with being a little more aggressive towards settlement in their stances in mediation?
In terms of the attitudes of lawyers towards settlement, again, it's difficult to overgeneralize. There are some plaintiffs who just need money, and they just need money now. And that's a reality of it. There are some defendants who simply need to put matters behind them and need to put matters behind them now because of other pressing issues in their business and personal lives. So there are people on both sides of the V, plaintiffs and defendants, who I've seen in the last few months, who are either sometimes taking less or sometimes paying more than you think they might, because the urgency of putting matters behind them. COVID has put tremendous pressure on people. You look at the unemployment rate, all you have to do is drive down any business boulevard and you see stores boarded up, restaurants boarded up. These are tough times for a lot of people.
And Jeff, some parting words and some tips for all of us litigators, because let's face facts, we all have to be, any litigator worth their salt is going to be involved in ADR. What do we need to know going forward? What can we do to improve the mediation system?
Well, as I mentioned earlier, to improve mediation, come with an open mind. Be committed to working hard towards settlement if at all reasonably possible. Understand your role as the lawyer, the mediator's role, and the client's role. It's like a stool sitting on three legs. You have to have balance for the stool to be stable. I would say to people, spend more time being curious than being on the attack. People who are curious learn more and are able to give their clients better advice about whether settlement is desirable, and if so, at what range, what kind of number. And again, the commitment to the process, not giving up too early, being flexible, being willing to have conversations in different configurations, meeting alone with the mediator, meeting with the other lawyer and the mediator. Perhaps having more joint sessions than people previously thought possible because we're operating in the online environment. Flexibility, curiosity, commitment. I think those are the things we need to maximize in order to have effective mediations.
And I agree with you, Jeff. And I have several times talked to some of my clients who's like, why are we going to this? We're going, look, even if we don't settle, this might be a good opportunity for information gathering. We might learn things there that we would not have otherwise known, not just from reading the briefs, but during negotiations.
And not only that, Hillary, but even if you can't get a settlement, you can figure out why you are not yet able to settle this case. What's the issue? Is there one person's deposition who we really, really need to take to answer a question? Is there document discovery that we really, really need to get to answer a question? Is there legal guidance we need to get from the court? Can we shape a motion for summary adjudication or motion in limine? Something else perhaps to get the kind of guidance we need from the court. So it can save the client time and money because sometimes we function more like a status conference than like a settlement conference. And we help you figure out what sliver of the case to litigate next, and then come back to a mediation process rather than simply charging ahead full bore with plenary discovery.
Right, and I think that's something that a lot of people overlook is you can always come back. You can always come back to another mediation session. Good mediators are always more than happy to meet with you again. And sometimes that's productive. It's like, okay, here we are again and we're back. And sometimes after a few weeks or even a few months, they will go back to the same mediator and the issues that you could not work past before, they're doable and workable now. So I think that's an excellent point.
Well, that's right, Hillary. And many times you don't even need to come back for a second day of formal mediation and incur a fee like that. Many times we can move things forward and even get a case settled with just a few relatively short phone calls. And generally speaking, mediators are not going to charge for that. So think about that possibility as well.
Right, and I can attest to that they've been working with, including Jeff, several good mediators haven't even charged for their extra time. And it did make a difference in settling what went into going, I don't know if this is going to work. So that's an excellent point. Jeff, thank you so much for being here today. It is always a pleasure to see you. I know I always enjoy seeing you and hearing your insights, and you're always so calm, cool, and collected, which I'm sure is one of many things that makes you such a good mediator.
Well, thank you, Hillary. It's a pleasure to be here contributing to the good work of the Beverly Hills Bar Association. Thank you for conducting the interview. If people have questions, I believe anybody who has a question deserves an answer. My email is jk@jeffkichaven.com. My cell phone is area code 310-721-5785. I am happy to answer any questions that people may have. Thank you very much.
Thank you.